Yes, counsel. Good morning.
Good morning, Your Honors. Andrew Crouch on behalf of Nicholas Loring, who appeals from a single conviction for failing to register out of the Brockton District Court. Mr. Loring challenges his conviction here and the underlying sentence for lifetime community parole on two grounds. And the first ground requires this court to make a determination as to what the legal obligations were for Mr. Loring to register. The specific statute that we're looking at here is section of the sex offender registration law is Chapter 6, Section 178, F and 1/2, which details for individuals who are finally classified by the board as to what their registration requirements are. And in that first sentence, they require them to register annually with the police department and with the board. And then secondarily, as we move further into the statute, we get to the language that is at issue here, which is detailing additional obligations for an individual who is finally classified who has to participate in each subsequent year. And that is the language that we look at in terms of looking at whether there's a factual basis here to underlie a valid plea of guilt and also whether or not there was actually a crime committed. In looking at this each subsequent year, this court, in trying to divine or interpret the legislature's intent, looks at the clear and plain ordinary meaning and language of the language that is used in the statute. And I would suggest here where the legislature uses language in each subsequent year, and that ordinary meaning of subsequent means following in time or next, we put that together and say in the following year or in the next year are these additional requirements. Here, Mr. Loring moved onto Wyman Street in Brockton and registered in June of 2008. His birth month was September. Under a plain reading of the statute, Mr. Loring in the subsequent year would have been September of the following year that he was required to register or to verify his information. During that time, he does not move. His information is not at all changed. And the Commonwealth is in no way prejudiced. And as this court well knows, the legislature is presumed to understand the words and the meaning that it puts in its statute. And the legislature has, on a number of other occasions, where it determines that an individual should be required to register more frequently, it says so. We have homeless offenders who are required to register every 30 days. So here, if they had intended an updated or a more frequent requirement, it would have put that in the statutory language. Instead, what we have is what I would suggest is clear and plain language in each subsequent year. That has to mean something. And here, I would suggest the plain language means following year. Accordingly, along those lines, there's a second issue. To the extent that that language is somehow not clear, if there is ambiguity, as this court knows, the rule of lenity requires the interpretation to benefit the defendant here in terms of his having understanding of what is proscribed criminally by 178F and 1/2 as applied through 178H. Here, to the extent that I would suggest that at the outset, as I noted, that this is clear language. To the extent that it's not, there is ambiguity, then Mr. Loring is not to know what his registration requirements are. Accordingly, as this goes in terms of the context of how this case comes to the court, I would suggest that it was error for the trial judge, the district court judge, to deny his motion to vacate his guilty plea. And here, since there are no facts under Rule 12 that support a criminal conviction here, and there were insufficient facts that demonstrate that he could understand the consequences of a plea where he's actually pleading guilty to something that is not a crime, that is not a registration requirement, that this court should both vacate his guilty plea and then dismiss the underlying conviction. In moving, with the court's permission, to the second issue that is raised, and as largely talked about in my reply brief and in my brother's brief as the primary issue, here the defendant is, after he is convicted in a second and during the sentencing hearing, which is a subsequent proceeding to when he offers his plea, the judge discretionarily imposes a sentence of lifetime community parole. And he sort of presages this court's decision in Williamson, whereas a lot of judges sort of went the other way on it. It's important to note that both the judge and the prosecutor in this case recognize that the complaint is deficient in terms of what Cately would require and Pagan would require in terms of its generalized language for the imposition of an enhanced sentencing penalty. It does not include any of the necessary or essential facts, such as stating what his level is, his final classification level. It does not state what, that he has a qualifying offense. They acknowledge that flat on the record. And then there's some discussion about whether 178H(a)(3) can be done discretionarily or mandatorily. By the second hearing, the prosecutors come around to the view that discretion may be applicable. It may be something the judge can do, since they clearly can't do it mandatorily because the language is not there. And I would note that the complaint here arises out of the exact same county as Cately. It's the same court. We're dealing with the exact same language where it has that parenthetical language.
Is it your position, I think this is, but maybe I'm not correct, that whether it's discretionary or not, the same pleading requirements apply?
That is exactly my argument. And I would suggest
the same notice has to be given.
Correct. And I would suggest that that is Article 12 through Pagan and Cately, through the 14th Amendment and Apprendi. The case law has been very clear, where we look to impose an enhanced penalty. And this court said it very clearly in Pagan and then cited through Cately, where an individual is susceptible, that was the word this court used, susceptible to the imposition of an enhanced penalty. The pleading requirements that are required under Article 12 and under due process in the 14th Amendment have to flow through. Those essential facts need to be pled. Here they just clearly were not, and the Commonwealth attempts to sort of wring the last little bit of daylight out of Cately, and I don't believe that Cately or especially Pagan offered any daylight to obviate the Commonwealth's pleading requirements. And I think the due process, the notice requirements of both Article 12 and the 14th Amendment, I think the case law is pretty clear on these points, requires Commonwealth to plead certain essential facts. And where those essential facts are missing, the court cannot somehow excuse the Commonwealth from that by imposing under 178H(a)(3), presumably, a discretionary application of lifetime community parole, and accordingly, that sentence should also be vacated to the extent that the conviction is not.
I think this would follow. Because it is a sort of discrete enhanced penalty, you say what you say. If the judge were to say, I'm going to impose lifetime probation, there wouldn't be a problem, right?
Assuming it was not lifetime community parole under the...
Lifetime probation as part of a probationary sentence.
That would be something that the court could indeed, may be empowered to do depending upon how it's sort of done. But yes, but in this...
It doesn't need to be pled in advance. It doesn't need to be articulated in the complaint.
Here, what happens is we have an enhanced penalty that occurs because of certain essential facts that have to be pled. A court can certainly issue or come up with some sort of a possibility of probation for a very extended period of time. Whether lifetime would fall under other constitutional problems, depending on the facts of a particular case, is another argument to be made for another day. But here, lifetime community parole is a creature of statute. It is a creature of the legislature's own creation. So it's not as if the judge has discretion to impose lifetime community parole in the absence or in the application of what the legislature's standards are. So where those standards are not met, lifetime community parole cannot stand. So just in short recap, I would ask this court in the primary instance to vacate the defendant's plea, as there were no factual or legal grounds to support it as a criminal conviction, and then secondarily to also then dismiss the underlying proceeding, or in the alternative to dismiss or remove the lifetime community parole portion of his sentence.
Thank you, sir.
Thank you.
May it please the court, my name is Matthew Libby, Assistant District Attorney for Plymouth County, and I represent the Commonwealth in this matter. Just briefly touching on the defendant's first argument, I would suggest that the suggestion that registering with the police after you move relieves the defendant of his requirement to register annually in the month of your birth is contrary to the clear intent of the legislature, which is to keep close tabs on sex offenders.
But is it contrary to the clear words of the statute?
Yes, Your Honor. I would suggest that there's simply nothing there that suggests that you don't need to register twice in 1 year. And what I would suggest, Your Honor, is a hypothetical, which is if someone has a December birthday but moves in January, that person could go essentially 2 years before they're required to register again in the following December.
So that what does the subsequent year mean? Isn't it the subsequent calendar year, the calendar year that follows the year in which you're registering?
You're right. I believe the subsequent year is referring to once someone's classified, they're required to register in each subsequent year in the month of their birth. And I would suggest that that holds true regardless of how many times someone moves. If someone moves 3 times in a year, I would suggest they're still going to be required to register in the month of their birth.
Are there registration requirements and notice requirements that attend moving?
Yes, Your Honor.
Don't you have to re-register at that point?
Yes.
So they're already registering. It's not like they've been lost in the system for the subsequent year requirement.
Right.
That's correct, Your Honor, but there's nothing in the statute that would suggest that the offender is not required to then register in the month of their birth, even though they've already registered in that.
Unless we don't agree that subsequent year means subsequent year.
But to take your hypothetical, that wouldn't happen. If somebody, I forget which way you had a January birthday and moves in December, is that the one you were talking about?
I believe it's a December birthday and moves in January.
Okay, all right. Has a December birthday, moves in January. That person's going to have to register pursuant to the January move, right?
Yes, Your Honor.
So there's never going to be 2 years without registration.
Your Honor, if someone were to move, say in January, if someone had a birthday in December and they were to move in January of 2013, under the defendant's analysis, that person would not be required to re-register in 2013. And then for 2014...
Well, wouldn't that person have to register because he just moved?
In January of 2013,
Right.
that would have to be done. However, it would go all the way through 2013 and then all the way till December of 2014 until that person had to register again. So I would suggest that's almost 2 years. And I would suggest that's clearly contrary to what the intent of the legislature is. Your Honor, I would suggest that this case is distinct from the court's analysis in Cately and Pagan because in this particular case, there's a unique set of facts where the judge actually sentenced the defendant to the CPSL as a matter of discretion as opposed to a mandatory sentence. And I would suggest that this court has made note, particularly in Cately and Pagan, that where the sentence is mandatory, the Article 12 analysis comes into play. I would suggest that in this case, because it was imposed as a matter of discretion as opposed to a mandatory sentence, that same strict Article 12 analysis does not apply. And I would suggest that this sentence is constitutional because here the judge gave the defendant an opportunity to have a sentencing hearing where he reviewed the defendant's record, he made findings, and those are findings that are consistent with what the defendant admitted to during the plea. They're supported by the record, and the judge was free to impose that sentence as a matter of discretion. And for that reason, I would suggest that it's not unconstitutional. I suggest that the case law that this court has relied on deals more with mandatory sentences. With respect to Fernandez, the court notes that it's a mandatory sentence, which is there's no discretion there. It's a mandatory sentence on a drug case. It's 5 years, and that's the end of it. Here, because the law of the case essentially became that it was imposed as a matter of discretion, I would suggest that this is removed from the Article 12 analysis, and it should not be.
Why is that? Don't you have the same notice problems?
Your Honor, I would suggest that in this case, the notice problem dealing with a strict Cately analysis, I would suggest, and I acknowledge the court's decision in Cately, that the complaint would be not sufficient. However, here, I would suggest that the notice requirement is relaxed under Article 12 because it was imposed as a matter of discretion.
But why? I mean, if you're thinking about the purpose of it, so that the person knows there's a potential for an enhanced penalty?
Your Honor, I would suggest
You would have
that
to prove it also, right?
relying on Fernandez, Your Honor, I'd suggest that the court's noted that a valid indictment need not to notify the defendant of all the sentence possibilities to which he's exposed, except in a general sense. And I would suggest that in this case, this complaint did notify the defendant in a general sense of what he was subject to. And I would suggest that it does make note of the potential for the community parole supervision for life. I would also suggest that in this particular case, it's clear the defendant had actual notice regardless of whatever deficiencies there were in the complaint, that this was community parole supervision for life was something that he was facing. This is a defendant who, on the green sheet, requested a separate hearing. He filed a memorandum of law regarding the sentencing, which acknowledged the fact that the defendant was subject to this because he's a level 2 sex offender and because of his predicate offense. And this defendant is also someone who filed motions to eliminate, asking that the Commonwealth be prohibited from using the word rape, Commonwealth be prohibited from referencing the fact he's a level 2 sex offender. So for those reasons, I would suggest this defendant clearly had notice that this was a constitutional sentence because it was issued as a matter of discretion and not mandatory. And for those reasons, I would ask the court to affirm the defendant's convictions.
Thank you, counsel.
Thank you.